So, welcome everyone. We're going to give a few moments for all the attendees to come in. We're very excited to present our panelists today. Today, the main title of this panel is Geographic Profiling, Criminalizing Coercive Control. We have two wonderful panelists. They are going to introduce themselves, and we're going to have an excellent conversation afterwards. So if you have questions, we'll save them to the end. Thank you so much, and we look forward to a wonderful conversation today.
Don't worry at all, and good morning, everybody, and thank you very much for the kind words of introduction. The topic of my presentation then is criminalizing coercive control, and I'm going to be focusing in particular on the new domestic abuse offence, which has just entered into law here in Northern Ireland. So in March 2021, a specific offence of domestic abuse passed into law in Northern Ireland under Section 1 of the Domestic Abuse and Civil Proceedings Act Northern Ireland 2021. The creation of this offence was particularly timely, given the sharp rise in instances of domestic abuse in Northern Ireland during the COVID pandemic. The new legislation has the effect of criminalising coercive and controlling behaviour, thus bringing Northern Ireland into line with the other jurisdictions in the United Kingdom and Ireland, and also with relevant human rights standards. So this paper will examine the reasons why the new offence of domestic abuse was needed, and will engage in some comparative analysis with the corresponding legislative provisions for England and Wales, Scotland, and the Republic of Ireland. However, although the enactment of the domestic abuse offence is certainly a very positive development, there is still more that needs to be done as regards Northern Ireland's response to domestic abuse. So just in terms of domestic abuse here in Northern Ireland generally, according to statistics that were released by the police, during the 12 months from the 1st of January 2020 until the 31st of December 2020, there were 31,848 domestic abuse incidents in Northern Ireland, which is one of the highest rates since such records began. We are quite a small jurisdiction here, and so those figures are comparatively high. Since the beginning of the COVID-19 pandemic, incidents of domestic abuse have increased dramatically all around the world. Essentially, the measures which were adopted by governments around the globe in order to limit the spread of COVID-19, although necessary, have nevertheless had the impact of exacerbating the suffering of those experiencing domestic abuse. The nature of domestic abuse is that it occurs behind closed doors. And in April 2020, around half of the world's population were in lockdown. And measures mandating that people should only leave their homes for essential purposes and severely limiting social contact meant that many victims of domestic abuse were essentially trapped with their abusers with very little means of escape. And in such circumstances, even the simple act of phoning or texting a friend for support, or indeed phoning a specialist support service, becomes more difficult or even impossible if both the victim and the perpetrators are at home together for almost all of the time. The The situation was further exacerbated for victims who, due to pre-existing health conditions, were shielding from the virus and who could not therefore leave their homes at all. Indeed, such victims may have been in the position of being heavily reliant on their abusers in terms of purchasing food and collecting medication. It is common for perpetrators of domestic abuse to attempt to isolate victims by cutting them off from family and friends. And with lockdown and social distancing measures, this was automatically effected without any effort on the part of perpetrators. Northern Ireland was no exception to this trend, with the police having received by May 2020 at least 3,755 calls relating to domestic abuse since the first lockdown began in March of 2020. From the 1st of April until the 21st of April 2020, the police received 1,919 calls regarding domestic abuse, which represented an increase of 10% on the number which were usually received prior to the onset of the pandemic. And by the end of April 2020, 3 people had been killed as a result of domestic abuse since the beginning of the first lockdown. On the 23rd of March 2021, the Women's Aid Federation of Northern Ireland, which is an organisation which works with victims of domestic abuse, joined with a number of other organisations working in this field to issue a statement which asserted that it was clear from the outset that lockdown measures would exacerbate women and girls' experiences of violence and abuse and shut down routes to safety and support. Over the past year, this has been borne out in the huge increase in demand our sector has witnessed, the increasing complexity of need from those we support, the strains that frontline workers have faced in responding to survivors and trauma, the new ways that perpetrators are using COVID-19 as tools for abuse and control, and of course the tragic murders of women and children. However, the legislative position as regards domestic abuse in Northern Ireland was problematic. Prior to the enactment of the 2021 Act, there was no specific offence of domestic abuse in this jurisdiction. Instead, incidents of domestic abuse had to be prosecuted under general criminal law statutes, such as the Offences Against the Person Act of 1861. That was relatively unproblematic as regards acts of physical violence, but it was very problematic in relation to prosecuting cases of psychological abuse. And in recent times, it has been recognised that physical violence is just one aspect of domestic abuse, and that psychological abuse, which is commonly referred to as coercive control, can be just as damaging. The tactics of perpetrators of coercive control may include emotional abuse, such as blaming the victim or undermining her self-esteem and self-worth, verbal abuse, such as humiliation and degradation, systematic social isolation, economic abuse, for example, controlling all finances, threats and intimidation, and physical abuse. So according to Women's Aid, coercive control creates invisible chains and a sense of fear that pervades all elements of a victim's life. It works to limit their human rights by depriving them of their liberty and reducing their ability for action. And so with the recognition of coercive control came the realisation by many that a discrete offence was needed in order to capture the harms involved. The necessity for the criminalisation of psychological abuse has been recognised in regional and international human rights standards. For example, in the European context, Article 33 of the Council of Europe Convention on Preventing and Combating Violence Against Women and Domestic Violence, which is known as the Istanbul Convention, states that parties shall take the necessary legislative or other measures to ensure that the intentional conduct of seriously impairing a person's psychological integrity through coercion or threats is criminalised. So, given the growing recognition that specific legislative steps were needed in order to respond adequately to the issue of domestic abuse, coercive and controlling behaviour was criminalised in England and Wales under Section 76 of the Serious Crime Act of 2015. Abusive behaviour, including psychological abuse towards a partner or ex-partner, was then criminalised in Scotland under Section 1 of the Domestic Abuse Scotland Act of 2018. And in addition, coercive control was criminalised in the Republic of Ireland under Section 39 of the Domestic Violence Act of 2018. Steps had been taken towards rectifying the situation in Northern Ireland, and in 2016 the Department of Justice here had launched a public consultation on whether a specific offence of coercive and controlling behaviour should be enacted. Responses were generally in the affirmative, with respondents making the point that the introduction of such an offence would be a positive step, which would clearly indicate that domestic abuse in all its forms would not be tolerated in society. Respondents were also of the view that the creation of a specific offence would give the police the opportunity to intervene at an early stage, thus potentially preventing domestic abuse from escalating. Indeed, legislation criminalising coercive control was subsequently drafted for Northern Ireland. However, unfortunately, the passage of this stalled due to the suspension of the Northern Ireland Assembly from 2017 until January 2020. So that meant that until March 2021, Northern Ireland was the only jurisdiction within the UK and Ireland in which coercive control was not criminalised. However, upon the restoration of the Northern Ireland Assembly in January 2020, securing the enactment of such legislation was a key priority of the Department of Justice, and in March 2020, the Domestic Abuse and Family Proceedings Bill was introduced in the Northern Ireland Assembly. This was ultimately enacted as the Domestic Abuse and Civil Proceedings Act, Northern Ireland 2021. The passage of the legislation coincided with the first year of the COVID pandemic, and as the Minister of Justice stated during Assembly debates on the legislation, the crucial importance of addressing the issue of domestic abuse became even more apparent during the current COVID-19 crisis. So this factor may thus have contributed towards easing the passage of the bill through the Assembly, and the effect of the pandemic on levels of domestic abuse arose several times during Assembly debates on the legislation. So Section 1 of the Act is entitled the Domestic Abuse Offence, and essentially states that a person A commits an offence if A engages in a course of behaviour that is abusive of another person B. A and B are personally connected to each other at the time, and both of the further conditions are met. And the further conditions are that a reasonable person would consider the course of behaviour to be likely to cause B to suffer physical or psychological harm, and that A intends the course of behaviour to cause B to suffer such harm, or is reckless as to whether such harm is caused. And the offence can be committed whether or not the behaviour actually causes harm of the sort referred to occur. The parties are personally connected if they are or have been married to each other or civil partners of each other. They are living together or have lived together as spouses. They are or have been otherwise in an intimate personal relationship, or they are members of the same family. The offence is aggravated if the victim was under 18 and is also aggravated if a child is involved, for example, if a child witnessed the offence taking place. A person who commits the offence is liable on convictional indictment to imprisonment for up to 14 years. As regards comparison with the relevant provisions for England and Wales, Scotland and Ireland, under the Northern Irish Act, the domestic abuse can only be committed if A and B are personally connected to each other. And as with Section 76 of the English legislation, the relevant offence can pertain in situations beyond those in which the parties are intimate partners. However, under the Scottish legislation, the offence in question is limited to a course of behaviour which is abusive of the defendant's partner or ex-partner, and likewise the offence of coercive control found in the Republic of Ireland's Act must be committed against a relevant person, with that phrase being defined as the spouse or civil partner of the defendant, or a person who was or is in an intimate relationship with them. In addition, under the Northern Irish and Scottish legislation, for an offence to be committed, there is no need to prove that the behaviour actually caused harm, but simply that the behaviour was likely to cause physical or psychological harm, and that the defendant intended to cause harm or was reckless as to such harm was caused. And it appears that the need to prove that serious harm has occurred has caused some problems in establishing successful prosecutions under the English legislation, and it seems meritorious that this requirement was not adopted in the Northern Irish Act. The domestic abuse offence in Northern Ireland is aggravated if the victim was under 18. There's no equivalent provision in the relevant legislation of any of the other jurisdictions in question, and the inclusion of this provision in the Northern Irish legislation is to be welcomed. The offence is also aggravated if a child is involved, and an equivalent provision is found in the Scottish legislation. And the fact that the Northern Ireland Assembly has chosen to replicate this is meritorious, given the harm that can be caused to children by exposure to domestic abuse. As I said, the person who commits the domestic abuse offence is liable for up to 14 years imprisonment. This is also the case under the Scottish legislation, but a person who is found guilty under the English legislation or the legislation in the Republic of Ireland is liable on conviction to up to only 5 years imprisonment. And given the very serious harm which can be caused by coercive control, it seems meritorious that the Northern Ireland Assembly chose to follow the approach of the Scottish legislation in this regard. However, While the enactment of the new domestic abuse offence is certainly a crucial development, it is important to remember that this will not be a silver bullet as regards the issue of domestic abuse in Northern Ireland. Difficulties have arisen regarding the implementation of offences of coercive control, and it is likely that such problems may also occur in relation to implementing Northern Ireland's new domestic abuse offence. For example, it seems that there is quite a high attrition rate as regards prosecutions under the English legislation. Essentially, the discrepancy between the number of prosecutions and the number of police recorded offences suggests that the prosecution authorities are facing difficulties bringing cases of coercive control before the courts. Such problems may manifest in particular in cases in which the victim does not wish to give evidence in court, a situation which may arise if, for example, the victim wishes to continue the relationship, fears retaliation from the perpetrator, or distrusts the court process. The difficulty in prosecuting coercive control offences without the victim's testimony is the nature of the behaviour criminalised means that it is generally performed in private and cannot be easily evidenced through alternative means. Also, whilst it is undoubtedly essential to ensure that appropriate legislation is in place on which an adequate criminal justice response can be based, there are other aspects of responding to domestic abuse which are of equal importance, such as the provision of social support measures for victims and increasing awareness within society as a whole. Legal responses can only be one part of a comprehensive strategy to address a complex issue such as domestic abuse. Indeed, some would argue that far more important than criminalisation is the need for provision of state and state-supported resources to deal with the real problems that victims face, such as childcare, shelters and employment, and thus make it possible for them to have the economic and social independence that is a prerequisite to their freedom from abuse. So in conclusion, therefore, the enactment of the new domestic abuse offence for Northern Ireland is certainly an immensely positive development. The offence is expected to be operational within Northern Ireland by the end of 2021. And the Department of Justice has stated that a body of work is taking place to ensure that the necessary system and process changes are in place, that training is provided to police and public prosecutors, and that the public is also aware of the new offence. So the introduction of this offence brings Northern Ireland into line with the other jurisdictions within the UK and Ireland, and also with human rights standards in terms of criminalising coercive and controlling behaviour. However, the new domestic abuse offence will not be a complete panacea to the problem of domestic abuse in Northern Ireland. Difficulties may arise in relation to prosecuting the offence, and also legislation is in itself insufficient as regards addressing domestic abuse, and further sustained efforts are necessary to tackle this issue. Nevertheless, the enactment of the new offence certainly represents a crucial development as regards Northern Ireland's response to domestic abuse. Thank you very much.
Thank you very much for your talk on domestic abuse and the legislation in Northern Ireland. Is absolutely fascinating and a very difficult subject, but thank you for, we need to talk more about it. If you don't mind, I'll switch right over to the, we have a question for you, if you would feel comfortable taking it. It's from an anonymous attendee, and it says, is it more difficult to recognize and address coercive control against children compared to towards an intimate partner?
Yes, and that's a really good question, actually. Yes, and I think it probably is actually more difficult to recognise coercive control as regards children, because, well, I mean, in terms of like the parental relationship, for example, sometimes there can be a fine line between actually, disciplining a child in a necessary way, and on the other hand, exercising coercive and controlling behaviour. And sometimes with children, that line is a lot finer than, for example, coercive control between intimate partners, whereby both partners are adults or both people involved are adults. Also, um, collecting evidence as regards coercive control in relation to children can be problematic as well, because obviously, in a lot of cases, it will only be, say, the parents and the child that are present when that takes place. And, so getting witnesses to something like that happening can be very difficult. So, yes, I think that is certainly a good point. And yes, it is more difficult, I think, proving cases of coercive control as regards children as opposed to intimate partners.
That's very interesting. Thank you. And I'm very grateful to the attendee who asked that question too. Dealing with children and crime is very difficult. So again, we deeply appreciate your insight on this topic. So thank you so much. I don't currently see any more questions at this time, but everybody has your contact information. And this presentation will be made available to everyone after. So thank you again for your time. We deeply appreciate it. We deeply appreciate all of your research, all of the hard work you've done. So thank you for your time. I hope you have a wonderful day. And thank you to everyone who has attended. Thank you.
Thank you very much indeed. Thank you.